Thank you so much, Julia and Margarita, for those kind words. And I am just honored and delighted and blessed to be with you all today. I have, and to be here to celebrate the ongoing successes and accomplishments and fourth birthday of IPSI. Um, I just, as I was listening to you, Julia, and thinking about your energy and enthusiasm and vision and brilliance, I feel like IPSI is in very good hands and has a very bright future in front of it with you at the helm. And the focus on IP and sustainability, sustainable innovation really does resonate with me and with my work. And as you were talking, I opened up my computer because I'm like, I wrote something a few years ago, and I'm going to come back to that in a moment. But this evening, I have a slightly different title than what was originally advertised. It's not a problem. I didn't go too far afield, but just a little different. I realized there was no way I could speak meaningfully about both treaties as well as inclusive innovation initiatives in the U.S. So I decided to focus on the Riyadh Design Law Treaty, especially because there have been some, to my mind, interesting developments there recently. So tonight, this afternoon, we will be looking at the Riyadh Design Law Treaty and the illusion of harmony and inclusivity. So, Indigenous peoples and local communities had quite the year in 2024 because it was an amazing year for multilaterally inclusive IP, a year like no other. Concerns regarding the injustice of the long-standing dismissal of the contributions of the Global South, in particular, IPLCs, Indigenous Peoples and Local Communities, and in regard to the sharing of benefits from innovations that they had contributed to, led to discussions in a wide range of multilateral fora on these issues, not just the Convention on Biological Diversity and its Nagoya Protocol, but the FAO Plant Treaty, the Convention on the Law of the Sea and the BBNJ Agreement, even the WHO and its pandemic agreement. But these issues effectively commanded a permanent space in the IP agenda of WIPO by their inclusion in two treaties adopted last year. So have this, IPLCs are active stewards of biodiversity needing to be rewarded and incentivized. And when you were talking about sustainable practices, in one of my articles I had written about, even in extractive activities, we can learn so much often from IPLCs when they are, there was a study that was looking at a group in the Amazon basin whose livelihoods are based on extracting rubber and Brazil nuts and other things. And even though sustainable use resulted in higher loss than strict protection, the net loss of carbon under the sustainable use regime was still more than 4 times lower than that observed on other land. And so the idea of really taking a sustainable approach, even to extractive activities, and much of what is protected by IP involves extractive activities. I think having that mindset is really important if we want to preserve our planet. So, yeah, these two new treaties, which were the first new treaties at WIPO, the World Intellectual Property Organization, since 2013, they were both groundbreaking in their mention of one or more of genetic resources, traditional knowledge, traditional cultural expressions, and Indigenous peoples and local communities, all of which have been contentious topics introduced into the normative agenda of WIPO. Now, the GRATK Treaty, or the WIPO Treaty on Intellectual Property, Genetic Resources, and Associated Traditional Knowledge, which was adopted in May of last year, obligates parties to require patent applicants to disclose the origin of genetic resources and associated traditional knowledge used in creating their claimed inventions that are based on that information or those resources. Now, does that result in increased inclusivity for IPLCs? Yes, in a way. It may end up being more symbolic than anything, but the symbolism is actually also important. It helps in their being identified as having contributed to scientific achievements, so a form of participation in science. There's a potential for increased participation in monetary benefit sharing, and just being mentioned in a WIPO IP treaty, it's hard to communicate just how contentious even the mention of these topics was. I wrote a paper called The Design Law Treaty's Forbidden Words, and it was the same kind of issue in both treaties, but just not even wanting the words to be said or to be included. So that's the GRATK treaty. The Riyadh Design Law Treaty, which was adopted in November of last year, is styled as a formalities treaty. It's supposed to make it easier for designers to obtain protection in multiple countries by harmonizing various procedures in national offices. Now, industrial designs protect the way something looks, not the way it works. And so design protection can cover a vast range of tangible and intangible items. But for a long time, it was seen as a backwater, didn't get a lot of attention. That really changed during the smartphone wars, when Apple won a $1 billion verdict against Samsung that was largely, it was reduced on appeal, but was largely based on design protection for the iPhone, the rounded corners of all things. And that caused a lot of companies, a lot of individuals to take a harder look, a closer look at design protection and the benefits it might bring to them. And it's relatively inexpensive to acquire, especially as compared to utility patent protection, and yet provides injunctive relief and can be significant in terms of damages. Now, design rights are one of the least harmonized areas of IP. If you look at the TRIPS agreement, it devotes only 2 articles to industrial designs, compared to 6 for copyright, 7 for trademarks, and 8 for patents. So not a lot of agreement on what should be included in an industrial design regime multilaterally, at least not until this Riyadh Design Law Treaty. And that lack of harmonization does create challenges for large multinational companies. As among things, it limits their ability to benefit from another WIPO treaty, the Hague Design System, which allows you to file one application with up to 100 designs, but then it still has to be agreed by national offices that, yeah, we're going to grant you an industrial design. So not surprisingly, the lack of harmonization did begin to put pressure to build harmonization into national design regimes. And this was the focus of the beginning discussions around 2005 in WIPO's Standing Committee on Trademarks, Industrial Designs, and Geographical Indications on a new design law treaty. And one of the key features, the centerpiece, if you will, of the agreement was this closed list, a closed list of things that a country's design office could require an applicant to provide. And the idea is that, well, if you limit the things that the office can ask for, that's going to create more certainty for applicants. They're not going to have to worry about, well, you know, this country requires this, and I've got to figure out what this other country requires. So that closed list was one of the key procedural changes that, and at least called procedural changes, that was touted as being an important feature of the draft design law treaty. And because this draft agreement was styled as a formalities treaty, it really flew under the radar for quite a while. People weren't paying much attention to it. In fact, people really didn't start paying a lot of attention to it until I heard, oh, there's going to be a diplomatic conference and we might actually get a new treaty. But nevertheless, back in 2014, the African group of countries in WIPO took a closer look and realized that agreeing to the DLT with its closed list could actually be problematic. Not only in relation to policy coherence with work going on in the WIPO IGC, the Intergovernmental Committee on Intellectual Property and Genetic Resources, Traditional Knowledge and Folklore, but also other treaties that some of the countries were party to, like the Swakopmund Protocol relating to traditional knowledge and folklore. Also, it would limit policy space, and this area, design protection, was one that many countries had not paid much, if any, attention to, especially not low and middle income countries. They were not receiving a lot of applications. And there was a particular concern that not being able to require the disclosure of the origin of genetic resources, traditional knowledge, or traditional cultural expressions used in creating designs would be problematic because of concerns about misappropriation and the fact that many design regimes do not involve substantive examination. So you file your application and a registration basically is going to issue. The office is only going to check and see if it meets the formal requirements. And that then puts the burden on third parties to have to challenge that right as being improperly granted, to say that no, it actually doesn't comply with the substantive requirements of the law. I have found that it is true that a picture is worth 1,000 words. And so I want to show you some pictures of items that are or could be protected by industrial design rights and kind of illustrate the concerns that the African group, and as the African group brought it up, other countries started to have. Some of these, as I said, are registrations: chocolate with indigenous animal drawings from Australia. A lot of concerns about fashion. Our culture is not your couture. Valentino bags with chokwe masks. A design patent in the United States on Ghanaian Adinkra alphabet symbols. Louis Vuitton shirt based on Lesotho, Basotho blankets. Vera Bradley bags, again, Ghanaian Adinkra symbols. Mango sweater with designs from a Mexican community. Dior copying Romanian sheep vest in the British Museum, and now a registration for vests. Tory Burch, a Romanian coat. So many examples. And I gave a talk on this topic well before the DipCon in New Zealand. And afterwards, some folks from the New Zealand Ministry of Business, Innovation, and Employment, they came up to me and they're like, we have an example for you. And they sent me these pictures of shower curtains that have these really important Maori depictions on them. And there's an article about how profoundly hurtful and offensive it was to the Maori people that these important pictures were putting on these utilitarian shower curtains. I mean, and somebody was like, well, why would you want to take a shower and look at, why would you want, but nevertheless, it's the thing apparently. So lots of pictures, and it's very challenging to find these examples because you're searching Louboutin, Paloma bag. So this is Chichu Messi, a Nigerian diplomat, Ruth Akedeji, Harvard Law School professor, myself. We were really tasked with, I was an expert for the government of Mozambique at the time, trying to develop support for the African group position and searching for those pictures, and the kind of catalog of pictures grew over time, but it was really hard to search for pictures using words because designs, they use very innocuous words as the titles for the designs. But at any rate, what the African group did was insert into that closed list permissive provision, basically saying that, and this Article 3, a contracting party may require that an application contain some or all of the following indications or elements, and it had basically said, and nothing else. Well, what the African group added was that they could ask for a disclosure of the origin or source of traditional cultural expressions, traditional knowledge, or biological genetic resources utilized in creating or incorporated in the design. Now, that provision, there were very good reasons for wanting to have that policy space. And again, unlike in the IGC where they were seeking a mandatory disclosure of origin position, this was just policy space. That countries that want to can require applicants to disclose its information. And as I mentioned before, there was a concern about coherence, policy coherence, that you're arguing for one thing in the IGC, and because in the IGC they were not limiting at that time their arguments only to utility patents, but other kinds of IP as well, they would have been cutting themselves off from being able to even argue for disclosure in the design space if they had agreed to a closed list that didn't provide that option. So that, let me, if I can go back one. That insertion by the African group was really controversial, to put it mildly. It caused a bit of an uproar in the standing committee negotiations, so much so that it shut down negotiations on the DLT in the Standing Committee on Trademarks for 7 years. Demander countries, which are high-income countries, refused to discuss it in the SCT any further. It would only get discussed every year during the WIPO General Assemblies. And even though that was not the Africa Group's intention, nor choice, because the African Group was always willing to talk about it and came up with various formulations, it ended up being quite beneficial to the African Group because it allowed time for the GRATK negotiations to get to a point where there was a chair's text that looked like a treaty, because those negotiations were much harder. And the opportunity for savvy diplomats to take advantage of a side effect of the war in Ukraine to get agreement for the convening of 2 diplomatic conferences in 2022 that would be held in 2024. It was really a horse trade, and I'm happy to talk more about that in the Q&A, but that is how we ended up with 2 treaties. They went together. One really would not have happened without the other. Now, even for countries who were convinced by the pictures that I showed you that the African Group concerns were legitimate, and there were folks who were like, okay, yeah, I can see that, even though they didn't like it and didn't want to agree to it and wanted to find any way other than having those words to address the issue. There were some that were particularly reluctant or resistant to the idea of inclusion of the possibility of disclosure of origin of genetic or biological resources. And the idea was that, well, you know, a design only protects the way something looks. It doesn't protect the way it works. So if it's just protecting the design, you could make it out of a different material. It doesn't have to be a particular genetic resource. And, you know, so that should be irrelevant in the context of designs. Maybe not. Designs provide protection for the appearance of something, and that registered design allows the owner to exclude the actual products whose appearance infringes the design. And countries may choose not to extend protection to the design of an article made using illegally or improperly acquired genetic resources. And I also have this from the EU Registered Community Design Law, and it actually mentions texture and or materials of the product itself. And there's an example I used to like to use to illustrate the problem, an example from the utility patent context. I don't know if any of you have read the book Perfume or seen the movie, but it's about this guy set in the 1800s, Granule. He was born with no body odor, but he had a particularly highly developed sense of smell. And so because he had no body odor, people weren't comfortable around him. And he set out to develop the perfect perfume that would cause people to just love and adore him. And he was successful. Unfortunately, he did it by murdering young women and extracting scent compounds from their body to make his perfume. So fast forward to the 21st century, and should he be able to get a patent on his new, useful, non-obvious or inventive step composition of matter? It meets all of the requirements of patentability, but people generally recoil at the idea that he should be able to get a patent on this because he engaged in this illegal activity or immoral activity to come up with the invention. And it's true, in Europe, there are morality-based provisions that might allow you to reject a patent on that basis. In the US, we don't have something like that. But at any rate, the same idea that if someone breaks the law in creating their invention or creating their design, a country might choose not to grant rights to that invention or that inventive design. So again, more pictures, because biodesign is a thing, synthetic biology is allowing all sorts of wonderful improvements in the design space. There's a lamp made from mushroom material, a 3D printed seat. I love this one. This is a jacket made from black textile waste and mushroom mycelium, which formed a white fungal network across the material to create the pattern. So the pattern is not created by a human per se. It is this genetic material that formed this pattern, and yet it would be protectable under an industrial design rights system. Here's another one where designers used a swarm of 6,500 silkworms deployed as a biological printer in the creation of this structure that, again, protectable as an industrial design. Or bees actively building on a form, creating sculptures with the natural texture and shine of beeswax. Kimono made of kombucha, shrimp-derived bioplastics, genetically modified silkworms creating fluorescent silk, a scarf dyed in bacterial secretions. So again, it's the bacteria that are making the design. They make these secretions, and voila, you've got this beautiful scarf, and the design is protectable under a design regime. So genetic resources, this was all to show genetic resources are relevant in this space as well. And there are reasons to care about the use of genetic resources in creating an article covered by a protectable design. And law tends to lag behind technology. And the fact that most countries had not been thinking about design protection or their laws or what they might need, it was really concerning to think about foreclosing their ability to even ask these questions in the future. Also, there's a much closer link between utility patent protection and design protection than many people realize. So I have here design, in the United States, designs are protected by patents, so I'll call it a design patent, but it still only protects the way it looks, not the way it works. This is a design on a dual lumen catheter. This is a utility patent on the exact same dual lumen catheter. I already mentioned Apple with utility patents and design rights on their smartphones, and a surprising number of drugs, pills, are the subject of industrial design rights. So the shape of the pill, and then you can go and find, this is all in your area. I went to the Orange Book, you'll probably know what that is, that it's the way that you can find patents on drugs that are on the market. And so I was able to find the utility patent, or one of the utility patents for this same drug. So it's protected by utility patent, and its appearance is also protected by a design right. And so the same reason that countries wanted the GRATK treaty and wanted a disclosure of origin requirement there, the same reasons they might consider requiring disclosure of origin for genetic resources and design applications. So the DIPCON came, and it was bumpy, to put it mildly, especially because people didn't think it was going to be. They thought it was just going to be pretty smooth. So just to give you an example, the GRATK treaty is called the WIPO Treaty on Intellectual Property, Genetic Resources, and Associated Traditional Knowledge. This design treaty is the Riyadh Design Law Treaty. Normally, a treaty takes the name of the city that hosted it. They couldn't get anybody to host the GRATK treaty, so it ended up being at WIPO headquarters in Geneva because there was a concern that it would be a failed DIPCON, a failed treaty. But there were plenty of takers to host the design law treaty. And yeah, Saudi Arabia got it. So, but once we actually got to the DIPCON, it was surprising. Many countries took issue with the presence of substantive provisions in what was supposed to be a formalities treaty, things like a grace period, a term of protection. There was a provision introduced to require a minimum 15 years of protection for a design. This is not a formality. It's just not. And there were provisions that would require significant and, in many cases, undesirable changes to national practice for a number of countries. That resulted in reservations against several provisions, as well as a resolution on the meaning of several provisions. But finally, it arrived, and there I'm giving my closing statement on behalf of the African Union at 4:28 in the morning. These DIPCONs it's about wearing people down. They go all night, it's crazy. But then later that day, there's a lovely party, and now we have a treaty. And it just awaits 15 ratifications to come into force, but that is expected to happen in due course. But after the treaty was adopted, I noticed something interesting happening. Interesting, fascinating, troubling. There are any number of words that I could use. When you read descriptions about the treaty, generally generated by WIPO, it sounds like harmonization was achieved on a number of these contentious issues. So here's the entry from Wikipedia, where you can go to find truth about all kinds of things. And it does say correctly that the goal of the treaty was harmonization, and then it lists, and it's interesting, it says, as provided by WIPO, it lists as features of the treaty a maximum list of disclosures, closed list, a mandatory 12-month grace period, mandatory non-publication. These are features of the treaty. I'm like, oh, okay. And the same thing on WIPO's website. They have an executive summary of the Riyadh Design Law Treaty. And they say, it provides a predictable framework for design application requirements. All the indications that may be required, are clearly defined in the treaty and regulations, and filing an application after public disclosure, the treaty provides for a mandatory and harmonized grace period of 12 months. And keeping a design unpublished for at least 6 months. Yeah, the treaty allows applicants to retain control over the publication even after filing date. I'm like, okay. And then just a month or so ago, 2 months now, I guess, there was an article co-authored by a WIPO high-level official who's been involved with the Standing Committee on Trademarks for a very long time, probably since the inception of the negotiations on the Design Law Treaty. And this paper doubles down on this particular harmonization narrative. About the grace period, it says, the RDOT contains a very clear and unambiguous provision on the grace period. And goes on to say what it is and says, neither the regulation nor the resolution contain any restrictions to this clear rule. Okay. Similarly, regarding unpublished designs, it requires contracting parties to maintain the industrial design unpublished for a minimum period of time, at least 6 months. And then as to the closed list, which now it's Article 4, Article 4 deals with the maximum requirements for registration of industrial designs. The provision contains an exhaustive list of all elements that may be required as part of an application. It goes on to say what those are, and it says the decisive factor here is that the RDLT clearly states that no further requirements may be required. Okay, so have I painted a picture of harmonization to you? Very harmonized in everything that's being said. These combinations of statements seem designed to give the clear impression that the treaty requires all contracting parties to provide a 12-month grace period, non-publication of registered designs if requested, and that it provides a truly closed list of items a country can require. However, that impression is completely false. And that's why I wasn't sure if I wanted to record it, but it's okay, because I'm just speaking truth. All right, so that grace period is in Article 7, and yes, it does say a disclosure of the industrial design during a period of 12 months shall be without prejudice to the novelty and originality. Sounds mandatory. And it's true that the regulations nor the resolutions say nothing about that. But the reservations do. Article 31, reservations. Reservation on Article 7, any state or intergovernmental organizations whose applicable law at the date it becomes a party to this treaty does not comply with Article 7 may declare through a reservation that it shall not be bound by Article 7. A country can choose not to provide a 12-month grace period. And lots of countries don't have 12-month grace periods or 12-month grace periods as broad as the one there. Similarly, publication of the industrial design, Article 10, the ability to keep it unpublished for a period of time. Article 31, and doesn't just mention Article 7, Article 10.1. It allows a country to say, nope, not going to be bound by that. And then is Article 4 actually closed? No, it is not closed because Article 4 allows a country to require an indication of any information the applicant is aware of and that is relevant to the eligibility for registration of the industrial design, including prior applications or registrations and use of traditional cultural expressions and traditional knowledge. Now, many people think that means, oh, genetic resources got left out. You can't require disclosure of origin of genetic resources. No, that's not what it means, okay? Because it says any information the applicant is aware of and that is relevant to the eligibility for registration of the industrial design. Article 2 of the treaty says that this is a procedural treaty. Nothing in the treaty or regulations is intended to be construed as prescribing anything that would limit the freedom of a contracting party to prescribe such requirements of the applicable substantive law relating to designs as it desires. In fact, the treaty does not define what an industrial design is. It leaves that to national law. So national law, countries can decide what can be protected by an industrial design and what the eligibility criteria are for industrial designs. So not only can countries require disclosure of origin information for traditional knowledge and traditional cultural expressions, but also for genetic resources used in creating a design, or for uses of artificial intelligence in creating design, which is something that many countries are now wanting to know about. Did a human actually create this design, or was it created by AI? You can ask that under Article 4, as long as the country makes it relevant to eligibility. But that's not the narrative that's being spun. And you gotta wonder why. What is going on here? Not just what is going on here, because I think we'll see it. And I have to say that while the harmonization narrative creates a false impression today, it may become a self-fulfilling prophecy. And that is likely why WIPO is intent on publishing and pushing this narrative of a harmonized treaty. Now, WIPO's mission is to serve the world's innovators and creators. And most of the innovators and creators that use the industrial design system are from high-income countries and large multinational corporations that want a harmonized design law system. One of the tools that WIPO uses is technical assistance, and that's probably going to prove very effective in achieving this particular goal. Now, technical assistance, when done well, can be very helpful. But when done poorly, intentionally or otherwise, it can have pervasive and long-lasting negative effects on development. Let's see, okay. When done well, it can help countries build capacity, training IP officials, judges, helping with drafting of legislation, but it needs to be appropriate to the country's economic development level. But if it's not done well, if it doesn't take advantage of local considerations and needs, it may provide strong protection even when that is not needed or desired. And there's an article by Daniel Acqua. He calls technical assistance a hedge for exclusivity. It's an additional way beyond the IP right itself or beyond the IP treaty of making those rights go farther and provide more protection. I have here some examples of TRIPS Plus technical assistance provided by WIPO and others that are quite problematic. One example is a 2008 Kenyan Anti-Counterfeiting Act that included generics as counterfeit. So if you try to provide generics, you could be sued. It also allowed anyone with an IP right in Kenya or elsewhere to have that right enforced against counterfeits in Kenya. And all of you being students of Professor Priora know about territoriality. IP rights are territorial. So you can't say, oh, I got a patent in the United States, let me go enforce that in Kenya where I don't have a patent. That's what that law allowed. Technical assistance by large pharmaceutical companies, hopefully no one you represent. I've represented a few in my day as well, so all right. 2002 Cambodian draft patent law was drafted by WIPO. It did not include any number of TRIPS flexibilities. WIPO also had not even told Cambodia that as a least developed country, they didn't have to provide pharmaceutical protection until, at that time, 2016. And the 1999 OAPI Bagley Agreement, which is like the poster child for bad technical assistance, one of the most TRIPS Plus pieces of legislation. It prevented member states from making use of TRIPS flexibilities without going through a court procedure. No OAPI country, and these are a group of 17 French-speaking countries on the African continent, 13 of which are least developed countries. None of them could even use a compulsory license without having it issued by a court after a court action. And if you contrast the Bagley Agreement with what the US government does in relation to compulsory licensing, and of course the US government puts lots of pressure on countries not to engage in compulsory licensing. It's very much a do as we say, not as we do situation. The US government, and this is work, great work done by Knowledge Ecology International, KEI. They have a database of more than 350 contracts that contain a FAR provision, which is basically a form of compulsory licensing. It's a provision that goes in a contract the US government makes with any sort of supplier, and basically saying you can use any patents that you need to use to fulfill this contract. Don't have to list the content, the patents, don't have to notify the patent owner. So you don't even know if your patent's being used, because under Section 1498, you are supposed to be able to bring an action against the US government for money. You cannot stop the government from using your patented invention, no. But you should be able to get money. But they don't even have to say what patents are being used. Totally not in compliance with Article 31, but that's of TRIPS, but there is Article 44 of TRIPS, which says that you don't have to provide injunctive relief in certain circumstances. So arguably, it is still compliant with TRIPS Article 44, but it's just so very different. And this is one of the challenges with technical assistance and with these kinds of treaties, that you have differing levels of capacity to even implement the treaty and the flexibilities in a treaty in a way that would be beneficial to your particular national context. And Professor Akedeji, who's my partner in crime, we've done a lot of work together. It's just a deja vu. She wrote about WIPO's approach to countries after independence, getting them to basically say that they would, yeah, we're still going to comply with the Paris Convention and the Berne Convention. She said third-party interests of citizens of other countries, presumably Europeans, must be safeguarded in developing countries. Even at the decisive moment of independence, intellectual property laws were not directed at the domestic innovation environment, but rather were projected outwards to foreign nationals who would benefit from protection. Developing countries, in essence, serviced the international system and not vice versa. And I just see this same thing about to happen again in relation to the Riyadh Design Law Treaty and technical assistance. In fact, Article 24 of the Riyadh Design Law Treaty is a technical assistance provision. But look at what it says. It's almost internally inconsistent. It says it shall be development-oriented, demand-driven, transparent, targeted, and adequate. It says it should take into account the priorities and the specific needs of receiving countries, but for what purpose? For enabling the users to take full advantage of the provisions of the treaty. That mandatory 12-month grace period, having that list as closed as possible. All of those contentious things, if you want to enable the users to take full advantage of the provisions of the treaty, then you want to make it as harmonized and as many rights as possible in national law. That's challenging for many developing countries, and because you might say, well, you know, is harmonization really such a bad thing? No, there are many times that harmonization is useful and helpful, but it's just helpful to whom and for what purpose? So part of the challenge here is because many low and middle income countries have not been receiving a lot of design applications or using the design system, they're still not going to be benefiting from it in that way. This is Nirmalya Sayam with the South Center, who was also involved in the negotiations and wrote this earlier this year. He wrote that, you know, yeah, it may make it more affordable, speedy, and predictable for designers to register their designs, but only a few countries can effectively reap its benefits. That's because very few developing countries have design-intensive economies. 75% of the global industrial design activity in 2022 was by China, Republic of Korea, United States, European Union, and Japan. Only 2.9%, less than 3%, is Africa, Latin America, and the Caribbean and Oceania regions combined. Okay. Christine Farley, another academic, points out applicants from major economies file at home and also file abroad in even larger numbers. Applicants in middle-income countries tend to file only mostly at home if they file at all. Most LDCs receive no design registrations at all. But the DLT may result in an increase in filings from global corporations. You can expect that. That's its whole goal, to make it easier to get protection in many countries. And if so, these foreign filings could become barriers to local designers. So there are potential problems with this harmonization narrative and actually the embrace of these higher levels of protection that would then make developing countries more attractive for filing design applications, maybe increased IP litigation costs, increased filings from foreigners that raises the cost of goods, and also those cost of goods, because these are foreigners who are obtaining these rights, that's money flowing out of the country. This was discussed way back in 1976. Konstantin Vexos, he was talking about patents, but he talked about, you know, practically all patents in the third world are foreign-owned. And these monopoly privileges have balance of payments implications. And yet the R&D allocations in the high-income countries are not really influenced by patent protection in the developing nations. So there's this divorce between patent protection in the third world and incentives on the innovations concerned. In other words, the narrative is that we have to have strong IP protection or innovators won't innovate because they're afraid of being copied. And that does hold true in high-income countries. However, GlaxoSmithKline is not making any decisions about what drugs it's going to develop based on its ability to get patents in Mozambique. They're just not. And here you've got the ex-CEO of Bayer basically coming right out and saying it. When the Indian government granted a compulsory license on Bayer's Nexavar drug, he called the compulsory license theft. It wasn't theft. It was in compliance with international law. But he said, is this going to have a big effect on our business model? No, because we did not develop this product for the Indian market. Let's be honest. We developed this product for Western patients who can afford this product, quite honestly. In many cases, 70% of big pharma sales come from the US and Europe, also add in Japan. This is gravy, okay? What they can get in many of the poor countries, because the people there simply can't afford to pay those prices for the drugs. So low and middle income countries may be better off with weaker protection initially. Graham Dutfield has written about this, citing empirical research by Kim, that substantive harmonization can harm the economic development interests of some, if not many, countries. It will hinder rather than facilitate tech transfer to and indigenous learning activities in the early stage of industrialization when learning takes place through reverse engineering and duplicative imitation of mature foreign products. The inability to copy designs is problematic because those designs are protected. Again, we are talking about countries that do not have yet design-intensive industries. And attempts to impose substantive harmonization could be construed as trying to kick away the ladder that these countries themselves use to climb out of poverty and into developed nation country status. So, to conclude, are we seeing a more inclusive, equitable, and just IP system with the adoption of these two treaties that mention some of the subject matter that is of interest to the Global South? Not necessarily, and especially in relation to the Riyadh Design Law Treaty. The flexibilities to limit the negative impact of this constant upward IP rights ratchet may be blunted by the harmonization narrative we're seeing, by technical assistance initiatives. There's likely to be high pressure on these countries to ratify and to not claim reservations or resolutions that would give them more policy space, but to just take it as it is. And there are other rights that I did not talk about that are also in the Design Law Treaty that tend to expand the scope of design protection and other things. So, inclusivity, or the illusion of inclusivity, harmonization, or the illusion of harmonization. We see both of these in the Design Law Treaty, and the potential exists for it to be inclusive. The potential exists for it to be harmonized. Whether in the end inclusivity or harmonization will win out remains to be seen. Thank you. And obrigado.